For hundreds of years, through the Roman kingdom, republic, and later the empire, the institution of marriage was a constant in the daily lives of the Romans. Unlike the romantic weddings of today, marriage, connubium, in ancient Rome, was an arrangement between two families. Like much of Roman society, it was highly structured and bound by tradition and laws, but also subject to a lot of changes, and marriage and marriage law in ancient Rome changed a lot actually, and had a lot of specific exceptions and special circumstances where certain laws applied but others didn't. Thus, what I will be discussing here in this video will be generalizations, mostly based upon republican pre-imperial times, though imperial law and customs will be mentioned as well regarding marriage. But also keep in mind regarding the matters that I discuss here that there were throughout time a lot of exceptions to the things I'm speaking about here, because the Roman law traditions regarding marriage were very complex and changed a lot throughout time, and had specific exceptions regarding very specific circumstances. But generally throughout Roman pre-Christian history, in Roman law, marriage was a status either created by a simple private agreement called a conferiato, made between families and their heads by binding legal oaths, followed by a ritual of sharing of bread made of emmer wheat, pharios, being shared between the two people about to be wed, a ritual that required that you had 7 to 10 witnesses depending upon time period, and the saying of certain ceremonial words and prayers made by a priest and statements of oaths made by the people about to be wed. Also, the name of this type of marriage, conferiatio, comes from sharing of emmer bread or uniting of emmer bread in Latin. In addition to conferiatio, there were two other types of marriages in Roman law. The first was to get into a marriage by coemptio, a sale in public of the woman. The woman was quite literally sold off, with at least 5 witnesses present from one family to another. The woman, just like in the conferiatio marriage, had no say or influence in this matter. Finally, there was a third type of marriage, a marriage by usus, or habitual cohabitation, if people were observed to live as if they were in an official marriage without any other factors being present, then they could be considered married by default under certain conditions. And these conditions could sometimes allow a Roman woman at least some influence in choosing her future husband. Though regardless of method used for being married, these were mostly, legally speaking, the same type of marriage, mostly, with some legal exceptions, and eventual marriage contract agreements being disregarded. Though they were not the same from a Roman religious perspective, as having parents that entered into a conferiatio was required in order to become a Vestal Virgin, or enter into the priesthoods of several of the Roman gods. So conferiatio was considered the more purer form of marriage from a religious perspective, and ritual purity was important in order to enter the priesthoods of the gods in Roman society. Another aspect to Roman marriages were that marriage could either be cum mano, marriage with the hand, official marriage with a ceremony and transferal of control of the bride from the father to the husband, or sine mano, without the hand, acting as if married, but with no official ceremony of transferal of right. Thus, a woman could remain under the control of her father, as the official status of holder of the Patria Potestas, power of the father, had not been relinquished, either in official oath or in a ceremony that was legally equivalent. This often meant that a husband had less direct control of the wife, and she had more of a protected status, as doing wrong or violence against her would be the same as doing it against her father's family in matters of honor and also legally speaking. Thus, these marriages without the hand became more common the later in Roman time you went, and by the imperial period were pretty much the standard of marriage. Though it should be noted that no matter or if it was with the hand or without the hand, the woman was always subordinate to a man, as a woman was in filiam viri transibat, philaque locum obteniquebat, passing into her husband's family and holding the place of the daughters. So a woman was always subordinate to a man, either her husband or her father, in the same type of subordination under Patria Potestas, the power of the father, which I have made a video about, which you can check out after this video. It should also be said that in a marriage without the hand, the pater familias, the father of the family, had still the right to dissolve the marriage of his son or daughter unilaterally. That is to say, without the agreement of his children or of the fatherhead of the other family into which his son or daughter had married into, or the husband or wife that his child had married with. Though this right was reduced the further along in Roman time you went, and usually there did exist marriage agreements which limited the power of the father to unilaterally decide to end the marriage of his children. So in practice, it wasn't always that the father had 100% complete control over the marriage life of his children once they had married, though he usually had the right to deny a marriage or refuse to allow a marriage before the conditions for a marriage were met. So the consent of the fatherheads was vital in a Roman marriage. What was also seen as an important part in a Roman marriage was the dowry, in Latin called dos, a gift, which you made as a payment, usually made by the wife's family to her husband's family, usually to cover their household expenses, though various other agreements could be made, as long as this was covered under various agreements that had witnesses. The dowry compensation could be anything from monetary compensation to the giving of farmland, to the giving of animals, to the giving of houses or other sorts of property as the dowry gift. And sometimes the dos could merely be symbolic, but in any case it was considered an important legal part in creating a marriage contract. The legal age for marriage was 12 for girls and 14 for boys, though marriage in later ages were the norm. As for which people were allowed to be married, no marriage to one's parents or their siblings, or to one's own siblings, or children fathered by one's siblings, nor to anyone that had previously been engaged to one of these in marriage. The closest people that were allowed to marry were first cousins, otherwise it would be considered impure, which actually in Latin impure is incastus, from in, un, and castus, pure, which turns into incestus, which is the root word for incest, by the way. Furthermore, a legal marriage could not be contracted except between Roman citizens enjoying the rights of connubium. In addition, in early Roman custom and law, you had to be of the same class of patrician or plebeian in order to make a legal marriage, as this was a very important matter at first in early Roman time. Then later it was more or less only a social matter, and in the late Republic, even rich plebeian families regularly entered into marriage with patrician families. So this was something that was relaxed through the ages in Roman tradition and law. And these were the conditions in order to enter a primary marriage: a matrimonium justum et legitimum. And with a marriage like this came the affectio maritalis, the officiated wife partnership, which meant that the woman in the partnership rose to the rank in social status, equal to the husband. Of course, the woman was still subordinate to her husband, but vis-a-vis others in society, she now had a rank of her husband through the association of marriage, and this had both legal and social implications in Roman society. Because your social class status was very important in Roman society, and Roman society was actually a lot more divided than just patricians and plebeians, being merely classes of economical status. These groups had in fact their own legal distinctions. In addition, they had subclasses with their own legal distinctions and their own privileges and duties legally. So being married into one of these classes had important legal ramifications for a person. Anyway, a woman would, after marriage, become an oxor, a wife, and thus mater familias, the mother of the family. A position only she could have as long as she lived and was the wife or the father of the family. Because true Roman marriage was monogamous. You could only marry one woman that got the true status of being the true wife. Remember this, because this will become important later. And that status could only be lost either through death or through divorce. And regarding divorce, what the law required was that the intention to divorce was declared before at least 7 witnesses, 7 male witnesses. Sometimes this could be initiated by the woman in connection with previous agreements, in which case the dowry could be returned to the woman and her family either in full or in part, and the woman would either return to being under her father's Patria Potestas or become sui juris, her own judicial person. These matters were dependent upon marriage agreements and various factors surrounding the marriage. Men could usually divorce at any time if no marriage contract stipulations said otherwise. And divorce was actually first mentioned in legal writings in the early Republican law code of the 12 Tables, which pretty much could be considered the constitution of the Roman Republic. So the right to divorce was pretty much guaranteed in the Roman Republic unless it was given up through agreement. But interestingly enough, the 10th law of the 6th table of the 12 tables actually specifies that the husband must give a reason for the divorce, implying that in early Roman law, which was not the case in later Roman law, there existed customs against divorce without justification, whereas in later Roman law, the husband could simply say that he did not wish anymore to live with his wife, and that was considered good enough justification by itself. Though technically within the 10th law of the 6th table, the existence of the justification clause within these laws of the 12 tables kind of implies that there probably existed some sort of agreed upon customary definition of what was a good justification in the past that no longer applied in later Roman law, but most probably did not include just the simple justification of not wanting to live with one's wife any longer. And probably you had to motivate it a lot more in earlier Roman times. Because why otherwise would you have the clause that demands that you give a reason for requesting a divorce, if it was so simple that you could simply say that you wanted to divorce, as was considered a legitimate reason in later Roman law. Hence, it is probable that this clause served some sort of preventative purpose in the past against divorce, but was reinterpreted to no longer serve this purpose in later Roman law traditions. Now I've talked about Roman true marriage and divorce, but there were other types of near marriage relationships within the Roman legal framework, such as marriages with, of, and between foreigners, matrimonium juris gentium, that did not have Roman citizenship and thus were subject to other laws. Citizenship was inherited from the status of the mother, interestingly enough, in the case of children from these relationships. You also had special provisions for Roman men that married foreign women, that made it possible for citizenship to be granted to their children as well, but it was not automatic. The reason for only giving Roman citizenship to the children if the woman was a Roman citizen is due to the fact that women are always biologically the parent of the children, and thus you could guarantee the inherited citizenship of the parent. Marriages with foreigners could only be conducted through the allowance of the father and through seeking permission for an outside marriage with a magistrate. A matrimonium juris gentium did not grant the status of affectio maritalis, of being an officiated wife, and thus they were not uxor, and thus did not have the mater familias rule either, which for the foreign woman had certain legal implications. But otherwise, matrimonium juris gentium was pretty much the same as the primary marriage, matrimonium justum et legitimum, in most other regards. And then there was contubernium, a slave relationship based upon cohabitation, which was not equal to true marriage, but certain types of slaves could enter into this and get certain protections, such as ensuring that one would not be separated from one's partner or children when sold again. It was also a common relationship status to enter into as a freed slave. At the beginning of Roman history, freed slaves were forbidden from marrying citizens with full legal rights in an official marriage. This restriction was later removed during the reign of Emperor Augustus in 18 BC in his legal code Lex Julia, so that during the 1st century freed slaves were only prohibited from marrying certain people of high status, such as senators and some other magistrates and important people in Roman society. Furthermore, Roman citizens were not allowed to marry prostitutes or actresses, and provincial officials were not allowed to marry the local women, and soldiers were only allowed to marry in certain circumstances. In addition, women that had been divorced due to having committed adultery could not remarry in an official true marriage, and thus entering into a contubernium relationship was a way to bypass these issues and get a kind of marriage that was of a second rate. Even if it was not a true marriage, it still had a similar legal function to the true marriage, the connubium, in that it was a legally recognized monogamous relationship. And speaking about monogamy, having one legally recognized partner, polygamy, as in several true marriages, was forbidden by law and by Roman custom, and yet allowed two with lesser types of what could be called marriage, or at least similar to it in early time, that in practice was a type of extramarital legal relationship. True marriage, as in the connubium, and some other legal statuses such as the contubernium, and marriages to foreigners, were monogamous, meaning that you could only have one, and you could also only have one in relation to the other relationship statuses mentioned. But legal mating relationships could be polygynous, a man having several partners, because there were some other sorts of relationships where you could have multiple women too. Because a married Roman man committed adultery only when his female partner was another Roman's wife, or under a similar relationship status, or unmarried daughter, or his slaves, without having been given permission to have a relationship with these slaves. But foreign free women, as well as other men, were fair game to have relationships with as a man, as the Roman law did not concern itself with those relationships. However, the relationships that the Roman law did concern itself with was the relationships that were associated with the previously mentioned types of marriages and near marriages, in addition to other categories. And that was slaves and concubines, who were not the same thing. So I will explain concubinatus, the state of being a concubine, concubina. Concubinage could either be temporary for a set, agreed upon limited amount of time, or non-temporary, hence permanent until revoked by either party, based upon various agreements. Concubinage, importantly, did not give affectio maritalis, official marital status, but was not a type of mistress without any legal status either, which you can see in, for example, the Lex Julia de Adulteri. It was not considered adultery to sleep with someone under concubinatus status. And in matters of adultery, no legal distinction separated a married woman from a concubine, intent alone. Yet in reality and in the course of daily life, the uxor and the concubine had no resemblance whatsoever, nor could they be easily confused. The concubinatus status could almost be seen as a type of secondary marriage, though it was definitely not seen as marriage by the Romans, but as something else. Though related in practice, it was more like marriage than being a pleasure slave. It was rather a third category between marriage and a master-slave relationship. Concubinatus status was usually utilized a lot by lower class people that wanted to form cross-class relationships with higher class Romans, but not necessarily slaves. Often freed slaves entered into this with those of higher class, and was thus similar in use to the contubernium, though still legally distinct from it. It should also be noted that the title of concubine was not considered as derogatory in ancient Rome, as it may be considered today, and could also sometimes just refer to being a mistress with a certain legalized status. Because as a woman, you could only have a relationship of a carnal nature to a person that you had a legalized relationship status with, without committing adultery, which had various legal and social ramifications. One of the more interesting ones being that a Roman woman couldn't be in a legal homosexual relationship, unlike men that could do that. It is interesting to note that concubine status was a later addition to Roman marriage and relationship laws, and before the time of Augustus and his reforms regarding marriage laws. Concubine status actually overlapped a lot with usus marriage, that is to say marriage created through cohabitation, and various laws and rulings regarding that, which is rather natural when you think about it, considering that a concubina was someone that lived with and had a carnal relationship with another person, as if they were married. The conditions for concubinage were puberty by both parties involved, consent of both parties involved and of the family heads. It should be noted here that to enter into a concubinatus relationship, it actually required the actual consent by both parties involved, which was not the case with early marriage law, for example, but later law such as Lex Julia do state consent there too as important. Strangely enough, if a child was accepted from a concubinage relationship, only the direct father actually held Patria Potestas, the complete authority over the child, and the grandfather had no direct legal say in the child's legal status, which was not the case with official marriages. Furthermore, entering into a concubinatus relationship did not require a dus or dowry to make it official, nor did the man in the relationship have the right to kill the concubine. Thus, entering into this sort of relationship could have certain legal protections for a woman to enter into, in comparison to a more regular marriage. The downside to this type of legal relationship was that a woman could not share her man's legal and social status, like she could if she had done an official marriage. Speaking about status, the concubinatus status could be used to elevate slaves, as enslaved concubines were privileged under Roman law, as they automatically inherited freedom at the death of the owner, and any biological children that a concubina had birthed were excluded from being sold as slaves. Though it should be noted that children from a concubinatus relationship, if the mother was not a Roman citizen, were not granted Roman citizenship by default, as the children weren't necessarily seen as legitimate children of the father by default. Later in Imperial Roman law, concubinatus still did not produce legitimate children by default, like a higher official marriage would. In earlier Roman law, this was actually also the case too with official marriages, or with any relationship, as the legitimacy of the children produced from a relationship was solely on the discretion of the father to accept them as legitimate. Consequently, the gap in legal protections between concubinatus status and official marriage changed over time, making one more preferable over the other, depending upon the persons involved and the time period of Roman history we are looking at. Also, as an interesting side note, concubinatus status could actually also apply to men. A concubinus was a male concubine. I mentioned polygyny, a man having several women, in regards to concubines before. And this is actually a rather complex matter, as you were supposed by Roman social norms and technically even the law at times to only have one concubine or wife. But several historical examples exist of this not being the case in practice or in applied law, with for example Augustus' wife Scribonia complaining over the fact that Augustus had lovers that he ought not have been with. In addition to concubines, there were other women that a Roman man could have a legal carnal relationship with, and these were prostitutes and slaves. A Roman man had a right to do anything he pleased with his slaves in the beginning of Roman law. Notice that I said man because a woman that had intercourse with a slave was put to death by customary action. Though generally, to be a slave was, by definition, to be available for the master's uses, or for the uses of those that one's master wished to, quote, entertain, unquote. And it was not uncommon that slaves were forced into prostitution. Though speaking about prostitution, there should be noted that there was a difference between slaves and free women that were prostitutes, as prostitution among free women was under kind of a legal contractual status of temporary concubinatus in a way that slaves were not. You can see this sort of prostitution as a sort of contractual pleasure relationship. This is somewhat similar to the traditions of nikahul mutta, temporary pleasure marriage, which exist within certain traditions of Shia Islam. In any case, the reality of the situation for most of Roman time was that a Roman man could have several women, whereas a woman could only have one man. And there were complaints about this throughout Roman history that were voiced by people that opposed this inequality and wanted to enforce a more monogamous culture. In, for example, this statement as recorded by Titus Plautus: if a husband has had a clandestine connection with a prostitute, his wife, if she knows of it, has no right of complaint, but if the wife secretly leaves for a short time her husband's house, he can bring against her an action for divorce. Why this inequality in the law? And greater complaints and later pre-Christian imperial law granted more and more provisions against relationships outside of marriage, such as concubinatus status, sex slavery and prostitution. Also, throughout Roman history, even early Roman history, there existed this attitude that if you had several women and surrounded yourself with several women, that made you a weak man, easily dominated by your lust for women. And it went against the Stoic ideal that existed within Roman society. A Stoic ideal of temperance and of not letting your emotions control you, emotions such as lust. And in later Imperial Roman time, monogamy became both the de jure norm and the de facto norm of society. And this happened before Christianity became the state religion of Roman society. And in fact, it could even have influenced Roman Christianity to have promoted this ideal of monogamy that we see in modern Christianity. Though strictly monogamous Christianity as a norm in the entirety of Europe would not appear until much later, as for example Charlemagne, the ruler of the Franks in what is modern-day Western Europe, several hundreds of years after the fall of the Western Roman Empire, had several wives and mistresses, as the early pagan and Christian Franks did practice polygyny, and the later medieval practice of, for example, Danish and North Germanic side marriages was practiced by Christians in the early medieval period as well. So the Roman conception of monogamy, and especially the late Roman conception of monogamy, was a rather unique norm that appeared within Roman society, if you look at surrounding cultures and civilizations. And I hope you have found this video about Roman marriage and Roman monogamy and polygamy interesting, my viewers. Please post comments, ask questions in the comments, and push the like button.
Please do subscribe, as it would help the channel spread awareness about the humanities.
اشتركوا بالقناة من فضلكم.